Hey boss, the party's going great. I need to tell you something though. Hurt my neck dancing to karaoke. Can you send me to a work comp doctor?
No, look, I'm sorry that your neck hurts. Injuries at work events like this aren't covered by workers' comp. My hands are tied.
But I wouldn't have hurt my neck if I didn't come to this party. And you said we all had to be here. Plus, it was during normal work hours. We were paid, and we talked business.
Look, just take some vacation time and rest it up. That way you can get paid, because workers' comp isn't going to pay you anything for this.
In this video, you'll find out if your work party injuries are covered by workers' comp in Florida, and you'll learn how to safeguard your rights while celebrating, because the only thing that should be getting hurt at a party is the dance floor. How's it going? Domenic Celeste, the virtual accident attorney here, and I'm back with another video. For those that don't know, I represent people injured on the job and workers' compensation and due to the fall of another and personal injury all throughout Florida. Now, as usual, before we get started, I have to show you this disclaimer, so just hold tight. And with that out of the way, let's get into the video. As the holiday season approaches, many workplaces in Florida are gearing up for the festivities by throwing end-of-the-year holiday office parties. But what if you get hurt celebrating? Are you covered under Florida workers' compensation for your injuries and lost wages? What if you get hurt at some other work-related event? Are you covered then too? In this video, we'll break down what you need to know about workers' compensation and your eligibility for benefits after an injury at a work party or other event. So stay tuned, as the answers might surprise you. Before getting into whether you're covered by work comp for an injury that occurred at a work party or event, let's go over a few other important things that you should know. First, it's essential to understand the coverage aspect of Florida workers' compensation. Your injury at a work party or event may or not be covered if your employer isn't required to have workers' comp insurance. In Florida, most employers must maintain coverage if they fall into 4 specific categories. Those categories are employers in non-construction industries with 4 or more full or part-time employees, construction industry employers with at least 1 employee, state and local government employers, and farmers with 5 or more regular employees or 12 seasonal employees working 30 days or more. Now let's discuss the critical factor of timely reporting your work accident. In Florida, you must report any work-related injury or accident within 30 days of when it occurred or when you knew or should have known that your injury or condition was related to work. Failing to do so could jeopardize your claim. I always highly recommend that you report any accident or injuries in writing rather than over the phone, so that there's a paper trail, because employers often deny that you told them that you were hurt at work. According to Florida Statute 440.092 sub 1, injuries from recreational and social activities, including work parties, are only compensable, which just means that your injury was by accident and arose out of and within the course and scope of your employment if it is an expressly required incident of employment and produces a substantial direct benefit to the employer beyond improvement in the employee's health and morale that is just common to all kinds of recreation and social life. This means that you need to prove that attending the party was mandatory, directly benefited your employer, and that it occurred during work-related functions. While the chances of workers' comp coverage for a party-related injury can be low, providing solid evidence can significantly improve your case. And while this list that I'm about to give is not exhaustive, it's a good start. And the more evidence that you have supporting your position, the better your chances of getting your injury covered. Now, here are some tips when collecting evidence. Keep invitations or communications. The specific language that is used by your employer may become very important for the judge to decide whether you were required to be at the party or event or not. Take photos and video. This not only shows the activities at the party or event, such as if drinking was involved, but also records who was there, which is going to go along with the next tip. Document who attended, as they may serve as witnesses. Getting corroborating stories from others who attended may become helpful in proving your case. It may also give you an idea of who may testify against you. Confirm with your employer that your attendance was required. I would highly recommend that this confirmation be in writing. Many of the cases that I read have hinged on whether the employee's attendance was required or not. Obviously, getting a direct statement from your employer that you are required to attend is better than showing circumstantial evidence. which the judge can choose to agree with or not. Document if you were being paid for your time. Keep your pay stubs to show this. Also, if the event or party is during work hours, get a copy of the sheet that shows you were still on the clock. Parties and events during work hours or that you were paid for is strong evidence to support compensability. If you sustain an injury, seek medical attention immediately. Even if your employer doesn't send you, this creates an official record that aligns with your account of what happened. Go to a hospital or clinic and even pay for it yourself. If you do these things, not only will the notes taken by the nurse or doctor help keep a record, but the billing statement will be further evidence that you were there. Lastly, let's explore a couple of real-life cases to illustrate how these principles apply. One employee was injured at a bowling event held during regular work hours. They were paid for their attendance, and it was clear that attendance was mandatory. Court approved benefits, recognizing the event as a required incident of employment intended to boost morale and discuss company goals. In another case, an employee was injured at a company softball game that took place outside of normal work hours and where she was not paid. Despite being on call, the court determined that this did not meet the criteria for compensation, as she was not actively engaged in work-related activities. Remember at the beginning of the video when the injured worker and his boss were going back and forth? Is that accident injury covered? What do you think? He was hurt dancing during karaoke, and it turns out that the employer had paid for the karaoke machine. Also, the injured worker said that he was told that he had to be there. It was during normal business hours, and they talked about business. These are all strong factors working in the injured worker's favor. Of course, if being told he had to be there was in writing, that would be a lot better. But if the judge finds that the injured worker is credible in his other testimony, there may be a better chance the judge will find his testimony credible here as well. Also, he probably needed to go to a doctor on his own and collect some documents showing that he was paid for the time if that was the case. So with all the facts and evidence that we have here, I'd say that this leans a little bit more towards being compensable than not. So in summary, we explored critical aspects of workers' compensation related to injuries at work parties and events in Florida. We discussed how coverage depends on your employer's insurance requirements and emphasized the importance of reporting any work-related injury within 30 days to ensure your claim is valid. We also highlighted the legal framework under Florida Statute 440.092 sub 1, which outlines when injuries from social events are compensable. Remember to collect evidence like invitations, witness names, and go to the doctor to get medical records to strengthen your case. Finally, we shared real-life examples to illustrate how these principles apply in practice. And there you have it. Now you know if your accident and resulting injuries may be covered if you're ever hurt while attending a work party or event. If you or someone you know were injured at work or due to the fault of another, you need to hire an attorney. Give me a call any time of the day or night. I have a 24/7, 365 receptionist, or better yet, you can just text me, 561-935-3822. But that's it for this video. If you got value out of it, or if you learned something, please hit that like and subscribe button. To learn more, watch my previous video here, or watch a video I've chosen for you here. Again, I'm Domenic Celeste, the virtual accident attorney. Thanks for watching, and I'll see you in the next video. Happy holidays, everyone, and thanks for the support. I'm super close to 1,000 subscribers, and I wouldn't be there without all you.